Mochi Health is here to help you start your weight loss journey with caring, personalized support. Meet one-on-one with board-certified obesity doctors and registered dietitians who truly listen and understand your unique needs. Eligible patients can access affordable GLP-1 medications delivered right to their door each month. No insurance? No problem. Mochi Health accepts FSA and HSA, making care accessible and affordable. And with 24/7 customer service, you'll never feel alone on your path to better health. Get started with Mochi Health today. Take the free quiz at joinmochi.com and use code AUDIO40 at checkout for $40 off your first month of membership. That's joinmochi.com with promo code AUDIO40.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my exceptional co-host, Brett.
I hear what you said there, Alice.
Explain for the people. What did you hear?
We're back. Hearsay. Yay!
Yay!
Yeah, I know. You know, we recorded this. We recorded the first Hearsay episode
before we
started doing lives. Yeah,
like,
that's how long
literally,
ago it was.
I think it was, I don't even know. I literally cannot, when I just asked Brett, I was like, I honestly can't remember what we said in the first Hearsay episode because we had intended to do a next Hearsay episode on exceptions, but that never happened because Delphi happened, Idaho happened, Murdaugh happened, all the cases that were supposed to be quiet for the time being, nay, they were not quiet,
Nay.
but
I love you using the word nay.
Nay,
Nay,
not to be confused with a horse. But you know what? Leap Day, which is today, the day we're recording, bought us an extra day in this year of the 2024.
Y'all better enjoy this. It's like I told my daughter, this one only comes around every 4 years. It's like the Olympics of days.
Happy birthday to those of you who are turning 4, 8, 12, 14, whatever it is. Sorry you can only celebrate your birthday once every 4 years, but today is your day.
It'd be cool if you only aged like 1 year every 4 years if you were born on the 29th. That wouldn't really make any sense.
Be like the opposite of Benjamin Button.
The opposite, yeah. So, you know, if you lived 100 years, you'd really live 400 years. That'd be awesome.
That'd be a bit intense because I don't want to be a 14-year-old, 56-year-old person.
You would definitely have to like go to school. We'd have to have one centralized school for all the February 29th kids, and you'd have to marry somebody. You'd be like a vampire, right? Like
it would be vampire-esque.
A normie, they would just like, they would waste away before you.
A muggle, shall we?
Yes.
Well, with that all said, we are here to talk about hearsay. And here's why this is important. We've talked a lot about, you know, here's the interesting thing about the true crime world and podcasts and documentaries that you watch. You end up hearing a lot of things about a case that are not actually admissible in court at all. And this matters because when a case goes to trial, the case that you present, all the evidence that comes in has to be admissible, and the jury has to make their decision based on what they hear in court. They don't have all the extra record evidence that we hear in documentaries. When someone has a hot mic, when someone pulls open a book that was never going to be admissible for many, many reasons. When someone says, I heard this person say that he was going to kill her. Hearsay, you know, definitely not allowed in. And so that's why these rules matter, because oftentimes when you listen to all that extra evidentiary record, and you think there's been so much injustice, there's no way I would have convicted in that trial, it's helpful to know what the rules are and what allows things to get in and why those rules exist. They're actually to protect, you know, kind of like justice and fairness, these kind of overarching principles, and to protect the defendant, actually. And also what is exempted from kind of these categorical rules we've created that say certain types of evidence can't come in. that's what we're here to talk about today.
And Alice brings up a good point. It's worth just focusing on for a second. The fact of the matter, one of the reasons that a lot of these documentaries bother me so much is because there's a lot that's pernicious in them. And one of them is the way they do introduce theories and evidence, quote unquote evidence, and witnesses and all this other stuff that's never had to go through the crucible of trial, either through the rules of evidence to determine whether or not it's reliable, relevant, whether or not it's
Credible.
Yeah, exactly. Or overly prejudicial, and the crucible of cross-examination, where the people who were talking to a friendly documentary crew sound so convincing, but if they had to sit up there and answer questions from a prosecutor or a defense attorney, maybe it wouldn't go so well. So that's such an important thing to remind people of, and I think it's become more and more important because I will tell you what I think we're seeing. And this is we're now off the rails. If we weren't off the rails before with February 29th, they're now completely off the rails. True crime is so big, and there is this hunger for new content, stuff that you've never heard before, cases you've never heard before. And I think you're going to see more. In the beginning, I think it was easier, even if they didn't always get it right, it was easier to find questionable cases where you might have a false confession or someone who was innocent in prison. And even some of those, I think they didn't get right. But there were some people in those groups that were wrongly convicted. But I think as they continue to try and feed that beast, you're going to see more and more stuff come out there, documentaries, podcasts, everything else, where the people are very guilty, but they're going to try and present to you that they're not, because those are the most popular podcasts and documentaries are always wrongful conviction cases. People love those because it's a mystery and you have someone to root for. And we need to be ever vigilant on that, because if they are guilty, number one, they're dangerous people. Number two, they committed a horrific crime. And number three, there's always a danger that an actually innocent person might be fingered for that crime after they get out. So these are just important things to remember as we move forward in the true crime space, in the true crime world, and we see more and more of this stuff. And one of the things that we think is important for you guys to know are the rules, because then you know when you're watching a trial and something's kept out and people are freaking out online. I can't believe that there must be a conspiracy. The judge is for the prosecution, or the judge is in the bag for the defense, or whatever. You'll know the rules behind it. Okay.
With that,
So Alice, with that,
here's the thing. We're about to talk through this, but you can read it directly. All we are reading are the rules of evidence, specifically the federal rules of evidence, because most state rules of evidence are actually kind of modeled after the federal rule of evidence. You can follow along. It's Federal Rule of Evidence 803. And you'll see that they're written in a way that a layperson should be able to understand them. So if you're following along with us, don't take our word for it. Go look at what the actual rules say. We'll give you examples from, our experience, but know that this is not exceptions to hearsay as said by Brett and Alice. This is the rule book. Literally Brett has the rule book with him right now that lawyers have to know like the back of their hands, especially if you're, an in-court type of lawyer. So first of all, what's hearsay? Since we did this episode, 55 years ago, hearsay is an out-of-court statement for the truth of the matter asserted. So in other words, someone says out of court, he ran the red light, but you don't call the person who said it, right? You have a bystander who heard him and said, they can't take the stand and said, I heard Alice say he ran the red light, because you need the person who said it. That's the general rule for hearsay. But there are exceptions where out-of-court statements can be brought in. And this is what Rule 803 covers.
And the last time we were with you, what we talked about were, I don't know why they divide these up, but they were things that were excluded from the rule altogether. So things like the statement of a party opponent. So if the defendant said it, it comes in, even if it would normally be hearsay. There are a few others. You can go back and listen to that episode if you want to hear that. Now we're to the exceptions. Now, the reason that the exclusions and the exceptions are important is because one thing you can always say about hearsay is it's not for the truth of the matter asserted. We're offering this statement to show something else. The problem is that then can't be proof of an element of the crime. So, for instance, the only thing you've got, I'll give you an example that I've seen in real life cases. There's a guy who is a felon. He's not supposed to possess a firearm. And there are people in the house And his wife told me that was his gun. Okay. So the wife is saying to this witness that it's the defendant's weapon. Now, the wife doesn't want to testify at trial, and as we know, can't really be forced to testify at trial. So you're having to rely on hearsay from this person. If the only way you can get that in is through we're not really offering it for the truth, and then that's the only proof you have that the person who's being tried was in possession of that firearm, when the defense moves for a judgment of acquittal, the judge is going to grant it, because he's going to say, look, you don't have any evidence, admissible evidence on this point that the jury can even consider. And since there's no evidence for the jury to consider, they're acquitted. But if you can get the statement in through one of these rules or exceptions, then it comes in for the truth of the matter asserted, and you can use it as proof of one of those elements.
And this might sound really confusing. So you might be asking, why would that help you then if you are trying to let it in, not for the truth of the matter asserted? Because it sounds like it's not going to help you prove your case. Well, imagine the cases that someone said, there's no way anyone would have known. No one mentioned a gun. We were not, there was no conversation about guns at all. So it's not for the truth of the matter asserted, but showing that the conversation about guns had happened in the house, if that's why you want it. So there are, and also, by the way, it's kind of a sneaky way to try and get in. If you can articulate a reason that it's not for the truth of the matter asserted, guess what? The jury still hears it. You know, they don't have to explain in their deliberations, we did not take that as truth of the matter asserted, but they're still hearing the evidence. So that's why that's such a kind of sneaky, powerful argument for the attorney. So you are always trying to find a way to get it to be inserted as not for the truth of the matter asserted.
So we're going to go through the exceptions today, and I just want you guys to know this is Rule 803. And Rule 803 has a total of 23 exceptions.
Wow, so many.
Not including the subparts in some of those exceptions.
I actually don't think I knew that. I think I could list 10.
Get ready. And a lot of the ones you've heard of.
I don't know that we're going to go through all of them.
Oh, we'll
cover the next. We'll cover the next quickly, 10 in a year.
Look, we're going to have multiple episodes on, what are we talking about? Hearsay. So
we're going to have multiple on this because you have entire classes in law school for the rules of evidence, and I think no one understands hearsays and the exclusions and the exceptions until you actually practice. And so when these come up in the trials that are going to happen this year or next year, a lot of these issues will come up. So we'll revisit, but now you have a basis and, you know, kind of a law degree from Prosecutors University.
And let's just be clear, most people who practice don't understand it, so it all works out. Okay, now, this is Rule 803, which are things that come in whether or not the declarant is available as a witness. Now, why is that important? Because the next rule, Rule 804, has a whole bunch of more exceptions. But those exceptions you can only use if the declarant, so the person who said the hearsay statement, if they are unavailable to testify for some reason. So there has to be something that keeps them from being able to testify. One that's fairly common, the Fifth Amendment. Somebody's going to plead the Fifth because they don't want to incriminate themselves. They are therefore unavailable to testify. Even if they're sitting in the courtroom, they still can't testify because constitutionally they're prohibited from being forced to testify. In that case, the next set of rules we're going to talk about, 804, you might be able to use those to get the statement in. But for now, these are whether the person is there, not there, alive, dead, can't wait to get on the stand, asserting their Fifth Amendment. It doesn't matter. If you have one of these exceptions, you can put their statement in for any reason.
So the first one is a present sense impression. And I'm reading directly from the rule. It's a statement describing or explaining an event or condition made while or immediately after the declarant perceived it. And so you don't have time to ruminate or get your story straight. This is at the moment what you thought of the situation. And the idea behind this exception is just exactly what I said. You haven't had time to kind of get your story straight and think how it fits strategically into the, you know, greater investigation of the greater story. It is what you perceive at the time.
You have someone who runs a red light or is accused of running a red light, and there's a car wreck. We're going to have a lawsuit. And let's say that somebody is standing there, sees the wreck, and says to a person beside them, man, that blue car Totally ran that red light. Saw it with my own two eyes. Says that, then wonders. They can't find him. But they find the witness, and the witness says, well, I didn't see anything, but there was somebody who was here when I got here. And they said the car ran the red light. The blue car ran the red light. That is a present sense impression because it's a statement by someone describing something that happened, and they're making the statement immediately after they saw it. Now, one thing to remember about all of these, and the reason that we have these, a lot of times, a lot of evidence is going to be hearsay just because of the way life works. That's just how things are going to be. And we accept that, and we don't want to throw all the evidence out. So what we're trying to do is we're trying to figure out, is this evidence likely to be credible or not? And the reason we think this is because if someone says something immediately after they perceive it, there's less time for them to have forgotten. There's less time for them to be confused. There's less time for them to have heard other information from other people that may cloud their perspective. There's less time for them to come up with a lie if for some reason they would want to lie. So we assume that when someone makes a statement very, very close in time to what they're talking about, what they're describing that they observed, that it is more likely that they are telling the truth. That is a reliable statement, and so we're going to let it come in even though that person can't take the stand.
And now the second exception, kind of related, you can see how there might be some overlap, is an excited utterance. So it's a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. And the idea behind this is it's spontaneous, right? It's like a reaction, like kind of like if you didn't have time to actually formulate and think that thought, it just happened so quickly because you were in a stressful situation. So imagine maybe this is a case about whose gun it was, right? And a gun on the table, and someone who does not own the gun pretends to take it. And the person who really owns the gun says, hey, that's mine, without even thinking about it, right? And then it's like, oh, gosh, darn it, I shouldn't have said that. Now they know the gun is mine. That's an excited utterance, or I would argue that's an excited utterance because it was like in the heat of the moment. He's like, oh, don't take that. He didn't have time. It was spontaneous. He didn't have time to think about how it's going to affect him. And so a statement like that is an excited utterance. I personally think that present sense and excited utterance can be very similar and can be kind of confusing how you argue it depending on the situation.
Okay, so here's a scenario for you. Okay, I'll give you one from one of my cases. This was a shooting case, and the witness was related to the shooter. She was either his girlfriend or his wife or his sister. I don't know. Somehow they were related. So the guy basically shows up and fires a gun at her. I mean, she's standing on the steps and he fires a gun at her a few times. He misses her, which is good. Drives off. So the police are called. They don't get there for a while. And when they get there, she's like shaking, she's crying, she's screaming, and she's saying that this guy shot at her. She's telling the police that. Now, this wouldn't be a present sense impression because it's told a very long time afterwards. And it doesn't have to be long, but I mean, it took the police longer than it should to get there, like an hour to get there. Normally not going to get present sense impression there. But we were able to get it in under excited utterance because, of course, she didn't want to testify later on once we got to the trial. But the police officer could testify to what he heard her say. And the reason we were able to do that is we had this whole part of the direct where the police officer is going through exactly how she was acting, what she was doing, what her behavior was, showing that she was still under the stress of the event. Because once again, our assumption is someone who is still under the stress of the event, who's still in that excited state, they haven't reached a point where they're going to stop and think rationally, I should lie about this. I should make this up. I should change this part. They're still just reacting on adrenaline. And because we were able to show that she was still in that state, we were able to get that statement in. Whereas something she said the next day when she's calmed down, you would not be able to get in under excited utterance. And the great thing about excited utterance, unlike present sense impression, is depending on how excitable you are, that can last a long time. If you freak out about everything and stay freaked out about everything for a while, we're going to be able to get that statement in. So that's why that one is so powerful.
That's a good one. And that's a good point. But I mean, the whole point, what we're trying to get at is that you're saying something without kind of the planning and the strategy of misleading, the court or law enforcement. Okay. The third one in this rule is then existing mental, emotional, or physical condition. And the rule describes this as a statement of the declarant's then existing state of mind, such as motive, intent, or plan, or emotional, sensory, or physical condition, such as mental feeling, pain, or bodily health, but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to the validity or terms of the declarant's will.
This one is super complicated.
It really is.
As you can probably tell just from reading the statement. And the reason it's complicated is because if you allowed this exception to be too broad, it would swallow the rule. So, you have this then existing mental, emotional, or physical condition. So, in the whole sensory condition. So, you don't want to allow this to bring in any statement describing what someone saw. You don't want a statement, say it's from somebody, 6 hours after something happened. They're standing on the corner after the car wreck we were talking about earlier. They're like, oh, yeah, I was here 6 hours ago and I saw that car run the red light. Okay, that's not going to be a present sense impression because it was 6 hours before. They're not making the statement immediately afterwards. All those reasons to have it be credible are gone. It's not going to be excited utterance because they're not excited. So could you say, well, it's a statement of their sensory condition because they sensed through their sight that the car ran the red light and got in the wreck? And the answer is no. And that's why you have that not including a statement or of memory or belief to prove the fact remembered or believed. You just don't want to allow this to swallow that. The way this is going to work and the way it often works is somebody told me what they were going to do. So like somebody said to me, imagine the victim. I was talking to the victim and the victim said, yeah, I think I'm going to go down to the marina tonight and have a drink. And then they die. Well, you can put that witness on the stand and they can tell you what the victim said to prove that they went down to the marina that night where maybe the defendant worked or the defendant was there, something like that. You're trying to prove a connection. You can put that in there because it's a statement of their intent. It's their then existing mental intent of what they're going to do that night. And the assumption is that person in that situation, they would not be telling a lie. That is something that's reliable, and the person who hears it can relate it, and we're going to allow it in. And that's usually how it comes in. It can be something like, motive's a big one too. Motive, intent, and plans are big ones. Somebody says they want to do something for some reason, say what they're going to do. These are all statements that we'll let in. The other things, bodily health, pain, say somebody dies, and there's a question, were they poisoned or not? Or did they die of natural causes? Well, somebody calling up the neighbor and saying, yeah, man, I've had the worst stomach ache. I've just been sick all day long. And you want to prove that these symptoms line up with poisoning. And so you want to get these statements in, but it otherwise would be hearsay. Well, you can use this exception to do that. But what you can't do is use it to get in every single thing anybody ever said by claiming they use their eyes, so therefore it's a sensory thing, and we can get any witness statement in whether they testify or not.
And just by the way these exceptions work is exactly what we're doing. You're having to explain to the judge, so you're trying to get something in and the other side objects, hearsay. And then the judge will look at you and say, counsel, and if you think it falls within one of these exceptions, you have to argue that it falls within one of these exceptions. And the judge can always rule against you, right? Even if you think you are like dead right on for the rule. So just note that these rules are somewhat subjective and they're up to the discretion of the judge. So that is another very fun part about being a lawyer.
And I just want to say, some of you guys in the chat are talking about how complicated this is. Literally,
yes,
an evidence class is at least half hearsay. Some evidence classes are more like 3/4 hearsay. Classes will spend entire days on every one of these things that we're talking about. We're trying to give it to you in the quick and dirty version.
Let's put it this way. When I go to trial, the thing I always have with me, other than like my notes about the case and my outlines and my, opening statement, etc., the thing that I always have with me, and usually it's the only thing I ultimately carry with me around, is this like trifold pamphlet that is hearsay, exclusions, and exceptions to hearsay. And it is like not an 8.5 by 11. It's like one of those massive posters, but it's a trifold. So it's like 6 pages total because it's 3 pages on one side, 3 pages on the other. And it's size font like 6, Courier. It's impossible to read because this is so complex that in the moment you have to articulate the rule and why it is that is what I have like in my hand as my security blanket, not my notes about everything else in the case, because there's just so much that you have to remember and also make arguments about that. I don't know about you, what you bring to court, but that is what I have in my briefcase for basically every time I go to court.
Yeah. And look, we talked about preparing for trial a lot, and some of you wonder what that is. Well, one of the things it is creating outlines of the questions you're going to ask and the answers you expect to hear, and thinking about which of these answers are going to get objected to. So you're ready. So you've already thought, okay, this is a potential hearsay. What are some ways to get this in? And I've literally had outlines with the question, the expected answer, objection, hearsay, rule 804, whatever, this exception, so that I'm ready if they object. And so much of being a lawyer is preparation. It really is. And if you know these rules well, you can be devastating on cross and on direct when you object if the other person doesn't know the rules well. You can just destroy their rhythm, their ability to get the information out. I mean, it can be really painful. And some of y'all have seen this happen in trials that you've watched, where it's like every word the lawyer says is getting objected to, and they just can't figure out a way to. And there's nothing more frustrating than when you're up there and you ask a question, objection, sustained, and then you try and reword it, objection, sustained, and you're like, how do I ask this question?
And when you have to move on, but you can't move on because you have to prove your case. Like, I mean, this is why this is so important. And they may seem like technicalities, but it's these technicalities that win or lose trials.
And I've had a judge say, why don't you just ask him it this way? And I was like, yes, Your Honor.
That's a nice judge.
Yeah.
That's a nice judge.
Yeah.
They don't all have to do that. It
makes me feel like an idiot when they do that.
Okay. That was sidebar. Okay, going on. Number 4, statement made for medical diagnosis or treatment. So this is a statement that's made for or is reasonably pertinent to medical diagnosis or treatment and describes medical history, past or present symptoms or sensations, their inception, or their general cause. And the idea behind this rule is that typically when you are going to see the doctor, it's because you need a diagnosis from the doctor, or you need medication, or you need something. And the idea is most of the time you're going to tell your doctor something true about your medical state. So you're not going to show up with a bullet hole in your chest and the doctor's like, yes, ma'am, what can I help you with today? Nothing. Nothing is wrong with me today. Well, you seem to be oozing blood in a circular pattern around your chest area. Nope, nothing there. All good. No, what are you going to say? You're like, I got shot. So that statement can come in. I got shot. Did you actually get shot? Well, the fact that you're telling your doctor that, we put some weight into, because most people want a real diagnosis. They don't want a bullet stuck in them. They want that bullet taken out to be sewn up and to be treated correctly. Are they going to get tetanus? Are they going to get, all the things? So the idea is, because your diagnosis is, reliant on you telling truthful information to your doctor, we can trust this as an exception to hearsay.
And I'm sure that's generally true. But this is one I always laugh at.
Except for the whole drinking, smoking question.
Yeah. Or the fact that lots of people who get shot show up in the emergency room and are like, yeah, I'm not feeling well. So what happened? Hard to say. Well, it looks like you've been shot. Really?
How'd that happen?
How did that happen? I don't know. Yeah. So this one is.
I have seen reports of like stabbings, and they go to the ER and they're like, "Sir, were you stabbed?" I don't think so. I just woke up like this. Really? Yeah. Pretty painful. Can you tell me what happened, doctor? Looks like stab wounds. Huh. That's weird. I was asleep. I've read a report like that and I burst out laughing.
Obviously, plenty of innocent people have been stabbed and shot. There's a lot of people who get stabbed and shot because they're doing something they shouldn't have been doing, and they don't want to talk about it. So, okay.
Oh, gosh. Okay, we can
So that's recorded recollection. These next few are really big, and they're ones that we use all the time. Records of regularly conducted activity. So a record of an act, event, condition, opinion, or diagnosis if The record was made at or near the time by or from information transmitted by someone with knowledge. The record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. Making the record was a regular practice of that activity. All these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 902.11 or 12. The opponent does not show that the source of information or the method or circumstances of preparation indicate a lack of trustworthiness. So what is this? Remember, hearsay is not just what people say. It's not just what people hear. It's also things that are written down. So let's say you want to show the business hours. How late is a business open? Well, you could have somebody come and testify about that, or you could have like a document that shows when they're open that is prepared by the person who owns the business, along with a certification that says, I attest that this is accurate. It comes in, and it can come in under this exception. One of the reasons you do this, there's a lot of reasons you do this. Number one, because we assume that records that are kept like that, your attendance records for employees, your books that you keep, the prescriptions that you fill as a doctor. I mean, just imagining different crimes one could be charged with. We assume that these are going to be reliable ordinarily. Now, look, if, for instance, let's say the defense had evidence that you were cooking the books and that you actually had two sets of books and the books that you've turned over are fake. Well, that's when that last part of this rule comes in. If they can show, no, this is not reliable, they can keep it out. Ordinarily, they're not going to be able to do that, and it's going to come in. So number one, it allows that information to come in easily. And number two, it shortens the trial. You don't want to have somebody have to come in for every little piddling thing you might want to prove in a trial. This way, you can shorten the trial. You can introduce that evidence. The jury gets to consider it, but you're not having to put yet another witness on the stand.
Yeah, this is so helpful just for the length of the trial, because no one really wants the bank teller to like show their ledgers and explain, in detail what it is. So this actually is used a good bit. And the flip side of it is also an exception, and that's the absence of a record of a regular conducted activity. And that's evidence that a matter is not included in a record if the evidence is admitted to prove that the matter did not occur or exist, and a record was regularly kept for a matter of that kind. So think about timesheets. Everyone who comes in always has to, clock in and clock out. The fact that Brett did not clock in and clock out that day, the absence of that record when your regular practice is to always record that, can be let in as evidence that he wasn't there. He didn't clock in that day. And again, the important part here is that it's regularly done in the course of business. And the idea is that you always do this just to run your business, right? To make a profit, to do good bookkeeping. And you didn't create these records or lack of records in anticipation of trial.
The next one is very similar to that. It's public records, a record or statement of a public office. If it sets out the office's activities, a matter observed while under a legal duty to report, but not including in a criminal case a matter observed by law enforcement personnel. We'll come back to that in a minute. Or in a civil case or against the government in a criminal case, factual findings from a legally authorized investigation. And once again, the opponent doesn't show that the source of information indicate a lack of trustworthiness. So this is public records that are kept by the government, much like business records, are presumed to be accurate. They can come in. But there are some things that are really important. A police report. There was a case, we were talking about a case recently. In the chat, we were talking about it. I think somebody was in another group, and that group was talking about how suspicious it was that they had not introduced the police reports at trial. Why did they just have the police officer testify? Why didn't they introduce the reports? And the person was able to say, well, actually, they couldn't do that because that would be hearsay. That's not allowed. It actually also violates the confrontation clause. And this is why. If a police officer can take reports, and those reports can be used to impeach the police officer if what they're testifying about is inconsistent with what's in that report. But what you can't do is just have the police officer take the report and then just introduce that report into evidence. You cannot do that. It violates this rule, and it violates the confrontation clause because you can't confront a report. And those reports often have a lot of really damning information that needs to come in through witnesses, not what the police officer wrote down.
And this is really important, especially if you have, say, the officer who wrote the report have to testify, say, years later, and it was a very complex fact pattern or something. And you're like, I wish I could just have this report be entered into evidence. You can't. Now, one thing you potentially could do is to use the document to refresh the recollection of that officer. But this is how important it is that the document is not the evidence. They don't get to read from that document. What happens is you'll say, Your Honor, let's say he says, he can't remember the time of day of whatever happened, of the robbery. I cannot remember. It was 3 years ago. It's been a really long time. I just cannot remember. You have to lay the foundation of why this document would refresh the recollection. So you can say things like, is it your common practice to record in a report the activities of what you observed? Yes. What about the time? Yes. Did you write a report this day? Yes. Do you think that would refresh your recollection? Yes. Your Honor, can we give him his report, whatever, for purposes of refreshing his recollection? Yes. He'll look at it. You don't get to ask questions. Usually he has to give the report back to you so he doesn't read the report. And then you get to ask the question again, because what the idea is now it's jogged his memory and now he can testify about it and be confronted about it.
And the number of times where the officer is just about to go up and you're like, remember, the victim's name or the defendant's name is this, or it was this kind of car. And like, yeah, I got it. And they get up on the stand. You're like, okay, so what kind of car was it? I can't remember. It's like,
and then
would it help to refresh your recollection?
Worse is when you ask that question, like, I don't think so, man. I can't remember. And you're like, oh my gosh, you do this all the time. What the heck?
Yes.
So this is what we mean by trial is just so much fun.
And everybody, these people are all human. They're doing the best they can.
Of course. And they're under oath. Everyone gets nervous, even if you testify for a living. Okay.
And refreshing recollection is a huge hole that people drive trucks through because
absolutely
a lot of times they really are just reading from the thing. Okay,
absolutely.
Let's keep it going.
We'll keep it going. Okay. So that was public records. Another one, number 9, is public records of vital statistics. This is exactly what you think it is. Records of birth, death, marriage, if reported to a public office in accordance with a legal duty. And that's because we keep vital statistics for other reasons. It's not manufactured to prove a marriage in, a trial. So generally you can just enter that in.
And what you can also enter in is the absence of a public record. So let's say you're trying to prove somebody wasn't married. Well, if you can get testimony or certification is admitted to prove that the record or statement does not exist or a matter did not occur or exist if a public office regularly keeps a record of it. In a criminal case, this is an extra rule, a prosecutor who intends to offer a certification provides written notice of that intent at least 14 days before trial, and the defendant does not object in writing within 7 days of receiving the notice. So this goes back to the whole there aren't surprises in trial. If you're going to pull this, if the defense is going to, for instance, the defense is going to say, you're going to try and call that witness, but that's his wife, and she says she's not going to testify. Well, what you can do is you can go down and try and find a record, a marriage certificate. There's no marriage certificate. You can use the absence of a marriage certificate to prove that they're not married, which means she then can't use the privilege. Well, you got to let the defense know that. You can't just pull it the day of trial. They got to know ahead of time so then they can look into it because maybe, actually, they were married in a different state. And here is the certificate. You can imagine all sorts of reasons that you want to give the defense an opportunity to try and prove that there's a reason that the document's missing and it's not what you're trying to say.
Yep. The next two are pretty similar. I've never used these before, but you can kind of understand at root why these are just exceptions. So one of them is records of religious organizations concerning personal or family history. So this is a statement about your birth, legitimacy, ancestry, marriage, divorce, death, relationship by blood or marriage, or similar facts of personal or family history contained in a regularly kept record of a religious organization. And kind of related, also allowed are certificates of marriage, baptism, or similar ceremonies. Again, this is kind of the idea that there are these religious institutions that keep records for themselves, like baptism certificates and whatnot, marriage certificates within a church. They are kept by them in the regular course of business. Those are allowed in.
And this goes to what we were just talking about. So you go to the probate court and you can't find it and you're trying to use that as proof it didn't happen. Well, then they go to the church that married them and voila, they pull out the marriage certificate that they kept then that might be proof that you can show that. Similar thing, family records. Once again, these are things you just don't think people would lie about. So you've got family records going back that somehow show some sort of family history. These include things like a Bible. So you might have a Bible that has a genetic, or not a genetic, but a genealogy
family
in it.
tree.
And sometimes, family tree. You might see that. You could use that. Engraving on a ring, to my dearest wife, Mary. So let's say you can't find, there's no marriage certificate at the courthouse. The church lost all its files, but you're trying to prove a marriage happened. And then you find a wedding ring and it says, to my wife, to my dearest wife. Now, like, maybe they just called each other husband and wife, but you can still use that as evidence to prove that they're married. And that's something you're going to be able to get in. It's not going to be kept out. And that's another thing that's important to remember. This is just does the evidence come in? It doesn't necessarily prove the fact, right? It's not like, well, since they got in that family Bible, then I guess he is his grandfather, right? There may be other evidence that pushes back against that, but these are questions of admissibility. Do things get to come in front of the jury at all to weigh and consider when trying to make factual decisions?
Yeah, absolutely. Remember, the weight of the evidence is up to the jury. So this is just before them at all. Okay. This is along the lines of people don't tend to lie about this information. Records of documents that affect an interest in property. And this is because if you own property, that's probably kind of like the biggest asset you own. And these are records kept by, in the regular course of business. There are rules around these sorts of things. So as long as it's kept in a public office and that the statute authorizes recording documents of that kind in the office, generally this is allowed in. And similarly, statements and documents that affect an interest in property can also be let in, unless later dealings with the property are inconsistent with the truth of the statement or the purport of the document.
And this is all you're trying to figure out: who owns something, what they own, where they own it, what the boundaries are. I mean, just all these things that you assume when people make them, they wouldn't be lying. Now, the next one's going to hurt my feelings, at least. Statements in ancient documents.
This is a low blow.
Okay, I want everybody to think about this. How old do you think a document has to be considered ancient? Everybody take a moment. 1500s? I
know what my answer is.
1600s? What's your answer, Alice?
At least a century. So people who are no longer alive, that's ancient because they can't come to court and say, I was your grandfather.
That makes sense to me. It is a statement in a document that was prepared before January 1st, 1998.
I'm ancient.
That's an ancient document.
I'm ancient.
So, sorry, guys.
I don't even want to talk about
before
that.
Before 1998, you're officially ancient.
All of my diaries from before 1998 are ancient documents.
Yeah.
I've never.
I think now it's actually 1999 because I'm pretty sure the rule changes every year. It's basically 25 years.
I think that's right, which is still not ancient. But anyways, okay, moving along because there are 23, as we said. Number 17, market reports and similar commercial publications. So these are like market quotations, list directories, and other compilations that are generally relied on by the public or by persons in particular occupations. And again, since these are market publications, someone will probably call you out if you're lying about something. This is, widely read by the industry. There's some sort of like group accountability about the truth of what is being reported.
So I was highlighting the fact that Sophie somehow, 1998.
She was reading. Yes. I have to think she was reading because there's no way I would have guessed it.
So statements in learned treaties, periodicals, and pamphlets is number 18. And you allow these in if, number one, the statement is called to the attention of an expert witness on cross-examination or relied on by the expert on direct examination, and the publication is established as a reliable authority. Now, we use this all the time. So Dr. Henry Lee's up on the stand. He's testifying. He says, and this actually happened in the Michael Peterson trial. He's like, yeah, the blood would do this. Well, then the prosecution would be like, well, I have this book here that, oh, who wrote this? Oh, you wrote this. And you said X, Y, and Z. Well, that's a statement from outside that you're trying to use to prove that X, Y, and Z is true, not what you're saying. It's not just to impeach his credibility, which is also valuable, but actually to prove, no, you're wrong. It's the opposite of what you said. And the jury can consider what you said back in the day. They don't just have to take your word for it. now. And that's the kind of thing you can use and gets used often when you have expert testimony. So that one's important for that.
Okay, the next few I think are really interesting, Brett. So number 19 exception is reputation concerning personal or family history, a reputation among basically your family concerning the person's birth, adoption, legitimacy, ancestry, marriage, divorce, death, relationship by blood, adoption or marriage, or similar facts of personal or family history. So what would be allowed to come in is like, oh, we all knew that he was an illegitimate child. Like his father had an affair and the mother he lived with was not his mother. Whether that's true or not, I don't know, but everyone in town knew that about this family. That would be allowed in.
And once again, you're just allowing it in. It doesn't necessarily prove it, but it's something you can use. We'll go back to the marriage thing. You don't have the marriage certificate. You can't find a ring. You can't find the church burned down where they were married. But you've got 27 relatives who all say, well, we all knew they were married. We remember they used to celebrate their anniversaries like everything else. It's something you can use. This is one that's so fascinating because so much family lore isn't really true. I don't know if y'all remember the scandal with Elizabeth Warren and whether or not she was really Cherokee or not. And it was like this big deal. And what I remember thinking when that was happening, and I would be interested if some of you in the South have had similar experiences. Every single person that I know believes that like their great grandmother was at least half Native American. All of them. It is just like everybody believes it to be true. Whether it's true or not, it is family lore in basically every family in the state of Alabama, at least. I don't know if it's true in other places, but it is absolutely family lore for every family.
Similar to that, having grown up in like one of the 13, original colonies, my twist on that was, and I'm talking about Georgia, everyone I remember growing up in my like elementary school was somehow related to Christopher Columbus. I just remember that was like the most random thing because every year when, now he's fallen out of favor for the mainstream, but like every Christopher Columbus Day, it was a holiday. We didn't have school. Everyone in my class, except for me, because I was the one not white person in the class, would be like, he's like my 19th cousin, 85th removed. And I was like, how are you all cousins? How are you all related?
See, when that whole alternative theory about how China actually discovered the New World happened, you should have been like, actually, I'm related.
I am related. I am Christopher Columbus.
It's the same thing with the Mayflower, right? Like everybody you meet in Boston was related to somebody from the Mayflower.
They might have been.
I mean, they might have been. That's the thing. It's plausible. So everybody claims it, whether they've got any proof of it or not. So that's a funny one.
I mean, all of these reputations I think are really interesting. So the 20th exception is reputation concerning boundaries or general history. So this is not a reputation about your family, but a reputation in a community arising before whatever controversies at play concerning boundaries of land in the community or customs that affect the land or concerning general historical events important to that community, state, or nation. So imagine, there's now a fight about whether this is tribal lands. It would be relevant before this lawsuit came about, where everyone was like, kids, don't ever play in so-and-so park because that is the ancient burial land of this tribe and it's haunted. If you go and, anger the tribal gods, you'll be haunted or whatever like that. That would be relevant for whether the people believed that the boundaries lay at the park.
Yeah, and these boundary disputes, you can imagine, you've had the boundary set for a couple hundred years, and all of a sudden somebody comes in and tries to say, no, actually, that's my land. I mean, you can imagine how that would be important. And once again, it doesn't necessarily decide the issue, but this is evidence you can get in. So we're almost done. We're getting to the close. Reputation concerning character. I love this one.
Ooh, this one's a sneaky one.
It is a sneaky one. So as we've said, ordinarily, we don't allow your bad character or good character in. So there's another rule that heavily restricts this. But if you can get past that rule, then you can allow in essentially the gossip of the community about your reputation. Everybody knew he was a violent guy. So when somebody gets on the stand and says, everybody knew he was a violent guy, objection, hearsay. Why is that a hearsay objection? He didn't say, John told me he was a violent guy. The reason it's a hearsay objection is because when you say everybody knew it, what you're really saying is, I have heard a whole bunch of people say things about how he has a terrible reputation. So that is going to be a hearsay objection. Well, this exception would allow it in if you can avoid the more general block against including reputation evidence. One way that can happen, let's say you're saying self-defense. This was self-defense. And I got to tell you, I'm a peaceful man, regular Quaker, would never raise a hand against anybody, wouldn't hurt a fly. But, I just had to defend myself in this situation. You put that forward as the defendant. Ordinarily, your reputation for actually being a violent guy who gets into fights all the time wouldn't necessarily come in. But once you put it at issue, then it does. And when it does, you can use testimony like this to prove, no, that's not true. He wasn't a peaceful person. In fact, that he had a huge reputation as one of the biggest fighters, in town.
Okay, there are a lot of caveats to this. An exception is a judgment of a previous conviction. It has to be evidence of a final judgment of conviction if the judgment was entered after a trial or guilty plea, but not a nolo contendere plea. The conviction was for a crime punishable by death or imprisonment for more than a year. In other words, it has to be a felony. The evidence is admitted to prove any fact essential to the judgment, and when offered by the prosecutor in a criminal case for a purpose other than impeachment, the judgment was against the defendant. And the pendency of an appeal may be shown, but it actually doesn't affect whether it's admissible or not.
So, give you an example of this that's really easy. Felony convictions. Felon in possession of a firearm is a crime you can be convicted of. If you were a felon, someone who was punished of a crime for which you can be imprisoned by more than a year and a day, you're not allowed to possess a firearm. Well, one way you can prove that is you get the person's certified conviction that says what they were convicted of. You introduce it into evidence under this rule, and now you've proven it. You had a statement made outside of court, which is the statement that says you were convicted of this thing and sentenced for this thing for this much time, and that's a felony. To prove that fact, an element of the crime, but you can bring it in under this rule. Last one,
we made it. It's judgments involving personal, family, or general history or a boundary. So this is a judgment that's admitted to prove a matter of personal, family, or general history or boundaries if the matter was essential to the judgment and could be proved by evidence of reputation.
There you go.
That's
it. Those are all the exceptions. You all now are ready to go out and try your first case. Congratulations.
But maybe go with that trifold.
Yes, maybe. But in all seriousness, hopefully this helps you at least a little bit when you're watching some of these trials and you're thinking about these issues and you're trying to figure out why is this allowed in or why is it not allowed in or why is there an objection? Because, one thing, speaking objections are generally disfavored. So a lot of times a lawyer stands up and just says, objection, hearsay. And doesn't explain why he thinks it's hearsay, doesn't get into the argument, and the judge will either sustain it or overrule it. And you may be thinking, why do you think that was hearsay? Well, now that you know the rules, maybe you'll think to yourself, oh, he thought it was this thing, but the judge overruled that, probably because of that thing, right? It's a hard subject. It's a confusing subject. You're not going to memorize these. But once again, I think hopefully just the general knowledge will help you out. And the next time, we're going to do what I think are more interesting, personally, rules. Rule 804. Rule 804 has some of the things you've heard about before, like dying declarations. I mean, this is a famous one.
Those are fun.
The last words. Alice killed me, right? And then they die. And then how does that statement come in? That is a hearsay exception. And that's the one we'll talk about.
I've always thought about what it like. You only get one dying declaration, I'm like, what would my dying declaration be? Like, wouldn't it be great to have one ready? Like, who cares? They may or may not find my killer, but like, what would be my dying declaration? So think about that, Brett, because I'm going to ask you that when we cover that case or that rule.
And just, spoiler alert. Actually, Alice, you can get more than one dying declaration.
As long as you think you're dying.
Exactly.
You can think you're dying multiple times. I thought I was dying all last month. I had lots of dying declarations last month. I was like, the
That's
flu,
right.
it kills. Oh, now we're just being nerdy. Anyways,
Yes.
I hope this was helpful. This was a good refresher for me, as always. If you guys have questions about these, we probably can't answer them. You probably have to go take like a 3-credit course in law school to fully understand the rules, and then you'll never understand them until you practice them and get berated in court by a judge about not knowing the specific rule you're citing to. So with that, Brett, is there anything else you'd like to add?
I will say this. I've never felt more ineffectual as a person than teaching an evidence class and teaching hearsay and just seeing the looks of utter confusion on all the faces in front of me and thinking, yep, not going to work out.
You
What are
could
you gonna
give
do?
all the examples in the world, and there are infinite examples that could or could not fall within the category that it's just like impossible to teach.
That's so true. Okay, Alice, do you
Wow.
want to answer a question before we
Yeah,
sign
let's
off?
do it. Let's do it.
Oh, this is a good question.
People's dying declarations are hilarious in the chat. I am laughing.
Okay, this is from Angthorn. What does ineffective assistance of counsel do to a lawyer's reputation?
I mean, if it's just,
nothing.
I was going to say, if it's just an allegation of IAC, ineffective assistance of counsel, nothing, because it's regularly asserted. Even if there's a finding of ineffective assistance of counsel, there are so many ways to do these. It depends what the actual finding is, but I have never really seen it ruin anyone. That wasn't a bar complaint.
Which I think is a problem. So when Strickland versus Washington came out, which established ineffective assistance of counsel, the Supreme Court naively believed it would be a very rarely used claim. And now it is the standard claim in every single conviction. If someone is convicted, they will make an ineffective assistance of counsel claim. Scott Peterson had one of the best lawyers in America defend him. He still makes ineffective assistance of counsel claims. And the fact of the matter is, it has so little effect on you that lawyers will often say they were ineffective because they just, that's part of defending their client. They just go
We
and say, "Yeah, that was
we
ineffective."
actually joke, like the defense counsel joke with us as prosecutors about it all the time. They'll be like, oh, just put it in your ineffective assistance brief. Like,
Yeah. It means nothing. And
it's like
so
a joke.
it is a total joke. And the claim, and it's, it's like every podcast, right? Every podcast about every crime that was ever committed. What are they going to say? The police framed them. The prosecution withheld evidence, and the defense attorney was ineffective. If you have an innocence podcast that doesn't make one of those, well, all three of those claims, I will be stunned because that is what they always say. So it really does nothing, and it's a problem. And I wish there was a way to fix that because it's important to hold lawyers accountable. Strickland makes sense in a lot of ways, but the fact that it hasn't translated to actual real world consequences for the lawyers means it's almost become like a strategy thing. Like they don't care. It does not keep an ineffective assistance of counsel claim. The threat of that hanging out there does not make a single lawyer work harder, better, doesn't make them investigate more, nothing. It doesn't do anything to encourage a defense attorney to actually work for their client. It's a broken thing in a lot of ways, but whatever. Okay, Alice. Well, I think that's all we got for today.
All right.
We went
Well,
long today.
Yes, we did go long. Thank you guys so much for hanging with us at Prosecutors University. I hope you learned something today. As always, reach out to us with legal briefs topics. We love talking about things that you want to learn about. You can email us at prosecutorspod@gmail.com. And also, check out our Facebook fan run group, The Gallery, and also check us out on social media. Apparently, we have TikTok now and Instagram and Facebook and X, Twitter at ProsecutorsPod. Find us, talk to us. We love hearing from you. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Speaking of words, this goes back to our conversation about like not cursing in front of my kids. So they don't know a lot of words to put down people. And so it's been really fun to watch them like think of words that they think are really, really bad. And so my oldest was trying to come up with a word to describe the messed up looking hyena in Lion King, you know, the one that was like has crazy eyes and whatever. And he was like, it's Ed. And I was like, oh, which one's Ed? I don't know. I didn't know they had names. And he was like, the, and he didn't have like a negative word, which I was kind of proud to describe.
That's good.
And he was like, he's the super bizarre looking one. And I was like, oh, that's like a really good description and also not too mean.
Oh,